Hello everyone, my name is Wilka Toppings and I'm a U.S. licensed immigration lawyer. Today I want to explain to you the basic requirements of the E-2 Treaty Investor Visa. The E-2 Treaty Investor Visa is a non-immigrant visa, usually granted for about 2 to 4 years of validity depending on the country of nationality. Most people around the world that qualify for E-2 visa will get a 4-year visa that allows you to come to the United States during that validity period and conduct business operations. So here you go. These are the requirements. The first requirement is that you must have established a U.S. company that from now on we're going to call the E-2 enterprise. This company must be engaged in active business operations. What that means is that it must not be a passive type of activity, like holding real estate, like owning a house and renting it, like having money in a mutual fund, or perhaps a very passive income stream. The E-2 visa requires the U.S. and E-2 enterprise to engage in the selling of goods or services or both. So it could be, for example, a retail store. It could be selling professional services like marketing, accounting, consulting, psychology, architectural services, graphic design, or it could be selling a restaurant or yoga studio. Those would be considered active business operations. The other requirement is that the applicant, the E-2 treaty investor applicant that will obtain the visa, be involved in the operation of the company as a director. That person must be directing and controlling the enterprise. And I want to underline controlling, because one of the major requirements of the E-2 treaty investor visa is that the investor control the E-2 enterprise. Control is decided or evaluated through ownership, shares, or membership interest in an LLC. Control is defined as owning 50% or more of the E-2 enterprise. So if you are a minority owner, you would not be eligible for the E-2 treaty investor visa. However, we may explore the option of bringing you as an E-2 treaty executive or employee if you don't own the majority. However, that has its own little requirements. For example, the main requirement is that the executive or manager that comes in under that scenario have the same nationality as the rest of the ownership of the company. But continue with the treaty investor requirements. The other requirement is that the investor must have made a substantial capital investment of personal funds into the E-2 enterprise. There is no definition, numerical definition of what a substantial capital investment is. It is left at the discretion of the consul when he or she evaluates the petition. However, the regulations do give us some guidance. For example, the investment must be proportional to the nature and size of the business that is established. For example, if you're going to establish a restaurant, normally a restaurant would elicit or require a higher investment to make the restaurant a viable investment. Perhaps you're establishing a small consulting company. Well, clearly a small consulting company is something that doesn't require that much capital outlay at the front to start the company. So we would evaluate the type of business, and that would give us a good idea of what kind of investment would be considered substantial. The other requirement is the company must not be marginal. Marginality is a very interesting concept in the regulation. What it means is that the company will, in all likelihood, generate a good living or good income for the treaty investor and his or her dependents to live from. So it cannot be a company that does not show ability to generate revenue sufficient for the investor to be able to make a decent living. Now, that's not a numerical, there's no certain amount of money. It's just, again, a whole presentation on how you feel and how we present the viability of this company. Normally, marginality is shown with a business plan, which is the main requirement of an E-2 visa. Every E-2 treaty investor applicant must present alongside the rest of the documents a business plan that will explain to the consul what kind of business we're doing, what are you going to be engaging in, what is your staffing going to look like, and what is your pro forma or financial. And that pro forma is over a 5-year period. That pro forma will then show the consul how does this company intend to make money and revenue and why this company will not be marginal. The last requirement is that the treaty investor must provide evidence of where he or she obtained the funds that she or he used to invest in his company. This is not a super detailed presentation. It's not like the EB-5 visa, which is the green card through investment visa. That requires a much more detailed presentation. The E-2 does require you to prove that your source of funds were from lawful or legal sources, maybe income, maybe it's a loan, maybe it's selling real estate, maybe it's accumulation of wealth, maybe it's good investments that you made. But nonetheless, we still have to have an explanation of where the money came from. It's perfectly fine for a family member or somebody to loan you money as long as it's properly documented. Now, if in the case of a loan, what is important to know is that the loan needs to be made to the investor personally, and then the investor needs to put that money into the company account of the E2 enterprise. So we don't want loans made directly to the company, because then it doesn't become personal funds of the investor, and that's one of the requirements. So those are some of the basic requirements, of course, that the E2 visa would require. There are other requirements, such as having an intent to return to the home country upon the conclusion of the E2 visa. Although technically you can be on an E2 visa for a long time, you can continue to renew the E2 visa as long as you have a viable business in the United States and a viable E2 enterprise. One thing that we want to mention is that a lot of people ask me questions about whether they need to have employees, American employees, and generate employment. Yeah, traditionally you have to show that you will be developing a business that will require some level of employment. However, it is not a requirement that they be employees on W-2 or full-time employment. These could be part-time employees, these could be contractors, people on commission, temporary workers. As long as you are paying someone else, you are paying cash out the door to someone else, that qualifies for the E2 visa and for a renewal, should we need to review. So again, the E2 visa is a great visa for those nationalities that actually qualify. Not every nationality qualifies in the world, but those of you that qualify, it's a great visa. It's a 4-year visa subject to extensions. You can bring your dependents as long as the children are under 21 years of age. They're considered dependents, and clearly if you have a spouse, that spouse can automatically get employment authorization unrestricted with the visa. The E2 investor would be restricted to working in the E2 enterprise. Now keep in mind that the E2 enterprise can actually expand into other lines of business. It can have subsidiaries and companies that are related, that you can continue having that visa under the E2 enterprise and then expanding your business opportunities somewhere else. So if you have any questions about this, or you want a more detailed analysis, contact Wilka Toppings at Toppings Law Firm. And you can find me on Facebook at Toppings Law Firm, or on our webpage, toppingslawfirm.com. It's a pleasure to speak to you, and I hope we can work together. Thank you so much.